My name is Paul Scanlon. I'm a very proud member of the Greens list, which has grown substantially to in excess of 200 barristers. Greens list puts on these presentations for the benefit of the legal profession. You don't need to hear about me, except to say that my role is simply to introduce the two speakers today. Just before I do, the topics for discussion relate to the medical practitioners, the defence thereof, and VCAT proceedings, and in relation to Paul Halley, the inquests and the health profession in terms of the Coroners Act. I had the pleasure many years ago of being junior to the late and great Peter Gelberly in the first cerebral palsy birth trial. And it was at that I realised the two different equations that exist in terms of the rights of people as opposed to the impact that it has upon medical practitioners. The child was born twins. Firstborn was fine, secondborn was caught in the ischial spines. They did not proceed to a caesarean and proceeded with the birth, and the child was oxygen deprivated and born with cerebral palsy. The plaintiff was awarded a very substantial sum of damages, courtesy of the late Gelberly, but it made me reflect on it later when the obstetrician gynaecologist who was looking after the mother effectively lost his career and went to research because of the publicity that surrounded the trial. And so, whilst we were very happy to have a substantial award of damages for the plaintiff, the impact upon the doctors was this particular doctor was enormous. It was, in effect, the loss of a great profession and a loss of a good man to the profession. And so a professional men and women have as their sole tool their integrity, their skill, and when that's damaged, it's a very terrible blow for them. Doctors are no different to anyone else in the community. They provide a service, but as you'll hear later, the defence of them generally and often in very unfair circumstances, in my view anyway, leads to unhealthy results. The first speaker I'd like to introduce is Paul Halley. Every time I see Paul, he's heading off to Bali with Michelle Brittbart, a member of the bar, Rebecca Boyce and Nikki Wolski, and those members of the bar who are also his friends are known as Halley's harem, and he's often seen with these ladies, and for reasons that I can't understand, they call him the spunk. Paul's been at the bar for 7 years. He's got extensive experience in the area about which he's about to speak. A former medical practitioner himself with a past graduate qualification in psychiatry and general practice, and I welcome you to hear from Mr. Paul Halley.
Good morning, everybody. It's nice to have an introduction that's not got any truth to it whatsoever. So I have been to Bali on a number of occasions, but I'm certainly not the spunk, and they're certainly not my harem. Now, echoing what Paul was saying previously about the effect of the legal profession and the legal system on medical practitioners is a very important point. I'm here this morning, hopefully, to talk about coronal inquests, but I would make this point that coronal inquests, although their purpose may be defined in the Coroners Act, which we'll be going through today, that they have wide-ranging effects upon medical practitioners. A medical practitioner has a finding, an adverse finding at the coroner's inquest against them, can be devastated by the effects of being associated with the death of one of their patients, and further there can be ongoing problems for doctors, such as disciplinary actions arising out of coronal inquests. So although coronal inquests are focused in the coroner's mind on a certain point, we as practitioners should be focusing very much on the more extrinsic points of a coronal inquest. That's protecting the reputation of health organisations and health professionals. I've provided a paper which I hope everyone has a copy of in front of them. Sean Cash said to me this morning just before we started that he didn't want to talk about the coronal process because this is paraphrasing him, there's nothing to say. It's probably correct, but despite that, I'll try my best to talk to you for the next 20 to 25 minutes. Now, I think most of us will be aware, if not all of us will be aware, that there's a new Coroner's Act in place at the moment. It's the Coroner's Act 2008. The Act commenced on the 1st of November 2009, and there are significant changes to the new Act as they pertain to medical practitioners and health organisations. And the paper really, in of itself, looks at those changes and sets out a template, if you like, of what are the things for us as legal practitioners representing health organisations or health professionals to look at in terms of when a coronal investigation or a coronal inquest is taking place. The introduction to the paper is plagiarised from the coroner's website itself, and this is seemingly a mission statement of the coroner's court, and it really sets out that importantly the coroner's court sees itself as really a therapeutic jurisdiction rather than an adversarial jurisdiction. It's well known that inquests follow an evidentiary basis that's different to other courts, but what's more important in my mind is that coroner is very sensitive to the needs of families during a coronal inquest. And if we're representing either families or health professionals, we have to be aware of the emphasis that the coroner's put on the needs of the family. And we may discuss this a little bit later, but one of the important things to recognise is that it's enshrined in the Coroner's Act that the Coroner's Court has to be sensitive towards the needs of the family. And when we're acting in the interests of people other than the family, it's prudent to note that, in my opinion, extensive cross-examination of family members who come to give evidence is seldom something that is productive of any forensic advantage, and often will put the family offside and put the coroner offside very rapidly. In line with that as well is a decision that I believe that we should be making very early on about whether we issue a public apology to the family on behalf of our client. I think it's something that should always be considered. I think it's something that helps. It helps diffuse things. Vanessa Nicholson is looking at me and thinking she doesn't want to apologise to anybody, but that's Vanessa's choice. But I think that the real issue is that Coroner's Court can be an environment that can be very fraught for the family, and if we're going into that environment and trying to mirror what the Coroner's Act is suggesting, we should be doing everything we can to make the environment less fraught. That doesn't mean you make admissions. That doesn't mean you don't defend the position of your organisation. But to make an apology can actually take a lot of the heat out of a coronal inquest. It can get the family into a position where they feel that they want to cooperate with your organisation rather than feel that they've been badly let down by your organisation. And as counsel, I tend to want to make an apology all the time, and maybe sometimes it may not be appropriate, but I think it's something that we should really turn our mind to, and making an apology earlier rather than later, again, is a good thing to do. Of course, the Act itself, I think it's Section 70 of the Act, does provide that an apology is not an admission of liability and can't be used in a detrimental fashion against your client. And as such, I see there's no good reason forensically not to apologise. In terms of the interaction between the court and medical practitioners and health organisations, the first point of call is when, of course, someone dies and they've been seen by a medical practitioner in the recent past or died in hospital or in other certain circumstances. I said that on page 2 of the paper, issues about what is a reportable death. There are a number of instances when a doctor will need to report a death, and I think it's important that the doctors know that if any unexpected death occurs while a patient is in their care or in hospital, it would be prudent to report the death to the coroner. It doesn't mean that it will be a reportable death, but I think the prudent line for a medical practitioner or a health organisation to take is to assume a death is a reportable death. The coroner and the investigating officers can then make a decision whether it is or not. There are penalties for failing to report reportable death, and the coroners, in certain circumstances when deaths haven't been reported and the death is a reportable death, are not very pleased with organisations for not reporting. So I would say, if you're advising it, if a doctor rings you and asks whether they should report a death, if they believe they need to ring their lawyer to ask that, they should be reporting it to the coroner's court. In terms of some of the specific circumstances that we should be alert to as well, is really anyone who prior to their death, and I think it's really interpreted in probably about a 3-month period, who was a patient, an inpatient under the Mental Health Act, those deaths should be reported to the coroner. And similarly, anyone who's on a non-custodial supervision order under the Crimes Mental Impairment Act and they die, those deaths should be reported to a coroner. There's also deaths that are called reviewable deaths. Reviewable deaths are second childs who to die in a family. There's obviously obvious reasons why such deaths are reviewable. One, there may be genetic or congenital problems that may exist in families, and it's important that those are reviewed. And secondly, that there may be other circumstances that may have led to the reviewable death. Again, doctors should be aware of their obligations under reviewable deaths, but there are certain exceptions to the need to report, and in particular, if someone is born in a hospital, stay in the hospital all the time and die in the hospital, and there's no circumstances to suggest that the death is other than natural causes, that's not a reportable death. But again, if in doubt, reviewable death, if in doubt, doctors should be reviewing those deaths as well. And so the coronal process is inquisitorial, and it starts off with an investigation. That presents real problems for those representing organisations or individuals in the coroner's court, because unlike other courts, you come to the court and the decision maker already has very clear preconceived ideas about the direction and what was the cause of the death. And I say this strongly, that it's very important that we involve ourselves very early on in the process of all inquests. The investigation is the genesis for what will happen at the actual hearing. And if we can, as representatives, influence the direction an investigation takes That's going to be very helpful for our respective clients when we get to the inquest. The coroner's role is not just to hold inquest, it's to be the investigator. And so the coroner comes to the first day of the inquest having been, in many cases, in control of the investigation for a number of years. And they can be very fixed on their ideas as to what has happened and what is the appropriate course to take. And it's very difficult to undo someone's mind rather than to influence an open mind. And so the earlier that we involve ourselves in the investigation, I believe that the more appropriate. Now, during the investigation, the coroner does have quite extensive powers. They involve powers to compel organisations or individuals to produce relevant documents, and also organisations and individuals or individuals who are representatives of organisations to prepare statements. It's important that we recognise that the provision of statements in an investigation is a very important step in the investigation, both for the coroner and for those that we're representing. If a statement is full, frank, and covers all the issues, it's going to very much help your client in the further preparation of their case. If a statement is evasive and unhelpful, you can be guaranteed that the coroner will further investigate and go off and get their own expert reports that often can be critical when there is no room for criticism. So again, I think it's important that we pay a great deal of attention to the statements that we do provide to the coroner, and that may involve conferring with counsel, may involve having statements settled at an early stage. The reason being is that the coroner does have very extensive powers of investigation and can compel people to give evidence and produce documents. And the more cooperative we are with the coroner at an early stage, the more we can influence the direction that the inquest takes. Having said that, there is a provision against self-incrimination for individuals. A medical practitioner does not have to provide a statement if that statement would intend to incriminate themselves. That would arise in situations particularly where I believe a doctor's been prescribing drugs contrary to the Drugs and Poisons and Controlled Substances Act, and is in a position where they may well be faced with criminal proceedings. In those circumstances, a statement doesn't have to be provided. However, that doctor would have to provide all documentation requested by the Coronal Inquest, and a forensic decision has to be made whether you're going to provide a statement or not. Again, I would encourage people to provide a statement at that stage, and you may want to quarantine what you say in the statement. The Act sets out when a coroner can investigate a death, and a coroner can investigate any death and hold an inquest into any death. However, there's certain deaths that the coroner must investigate. Relevantly for medical practitioners, those are deaths when a person is in a place of custody or care. In the respect of medical practitioner, that involves people under the in an institution under the Mental Health Act, or on a custodial supervision order or non-custodial supervision order, and in other prescribed circumstances. Now, as far as I'm aware, and Sean and the audience will correct me on this, but there have never been any circumstances that have been prescribed either under the old Act or the new Act. Almost invariably in inquests now, a directions hearing is held prior to the inquest, and again, a directions hearing is, I believe, a very important stage in the process. It gives us an opportunity to influence a number of factors. The scope of the inquest, which can be very important. Families, rightly in their own mind, will often want a very wide-ranging coronal inquest, looking at various issues which don't touch on the circumstances of the death itself. That may be appropriate in other forums, but it's certainly not the role of the coroner to undertake a wide-ranging investigation. The directions hearing should be used to converse with the coroner about what is the relevant scope of the investigation. The narrower the scope, the better in many ways. You can influence the questions to be asked at the inquest, influence which experts the coroner may wish to call. Again, the provision of your own statements, which are full and frank and have good explanation, can often avert the need for an expert to be called by the coroner, him or herself. You can influence the witnesses who will be called in the hearing and influence whether you are an interested party or not. Now, because of the effect that coronal inquests can have on medical practitioners and organisations in terms of their reputation, very serious consideration should be given to whether you are an interested party when you are involved in a death of a patient. That there are forensic advantages of being an interested party. Similarly, there are forensic disadvantages of being an interested party. And in certain circumstances, if your role is one that is less central, it may be preferable that you try to obtain limited leave for representation at an inquest. What that does is allows you to have representation for that part of the inquest that touches on your client, but quarantines your client from any adverse findings. If the coroner is going to make adverse findings against an organisation or an individual, that person must be an interested party, and that person must be invited to partake in the whole of the inquest and to be able to make submissions. So I'll just put that out there that it may be preferable at some times, if the coroner agrees with you, to obtain limited leave to appear. Of course, that can change during the running of inquests. Inquests take their own organic process, and it may be that a limited leave has to be translated into full-blown leave, but it's an interesting forensic question and something that we should turn our minds to at an early stage. During the running of the inquest, again, the coroner has wide-ranging powers. The coroner can summons people to produce documents, and of course summons witnesses to appear. Now, in terms of documents, an issue that arises often is the issue in relation to root cause analysis that are carried out by health organisations after a death. There are different approaches taken by different organisations and different legal representatives. I would say this, that if a root cause analysis has been undertaken, a root cause analysis is basically that the organisation looks into the circumstances of the death, looks if there are any systemic issues that may well need to be addressed, and looks to address those and go forward by making appropriate changes. It's a process of audit, really, but specific to circumstances of death. If such a root cause analysis has been undertaken, a decision needs to be made early whether that is provided to the coroner or not. Argument can be made that root cause analysis should not be given to the coroner, and the document should be quarantined from the coronial investigation. And that's really on a public policy type argument that employees and agents of organisations may be less willing to be full and frank in their disclosure to that organisation if they know that that document or that their statements will create the genesis of a document that becomes a public document. What I would say, though, is some coroners have no truck with that sort of argument and do use their powers to require the production of a root cause analysis. And so it's often takes the sting out of things to be aware of what's in that root cause analysis very early, and if it's good, in terms of it shows that the organisation has looked into the death, has looked at the systemic deficiencies, if any, has identified need for change and implemented those need for change. That can almost be a document that will supplement the need for the coroner to hold an inquest. That might end in the coroner being satisfied and the whole process stops at the investigation stage. Also, even if it does go to inquest, it can form the basis of the findings of the coroner. And it's much better to have findings of a coroner that come from your own perspective and perspective where you do have control over changes and can look at ways that implementation of changes can be put into place, rather than a coroner having no such root cause analysis and imposing what the coroner believes to be appropriate changes for the health organisation to make. So that's food for thought, and my viewpoint is if one has been carried out and it's been carried out diligently, then it should be provided to the coroner. The coroner can make recommendations to health organisations, and health organisations are obliged to reply to those recommendations in writing within 3 months, setting out their consideration of those recommendations and what they've done to implement any changes arising from those recommendations. Coronal inquests will often occur 3, 4, 5, even 6 years or later after the death of a person. And if the health organisation kind of made changes prior to the holding of the inquest, it really, again, I say, nullifies much of the role of the coroner. I'll finish on this. I'm sorry I'm been a bit slow, but it's a bit early in the morning for me. Another issue that arises during the running of inquests is an issue in relation to whether a witness should be given evidence, having been asked to give evidence by a coroner. The issue really arises in circumstances where a health professional could potentially be facing criminal charges or charges under the Occupational Health and Safety Act. Section 57 sets out the powers of the coroner to compel a witness to give evidence in such circumstances. What it provides for is that a witness or their counsel can ask for a certificate in relation to such evidence, and what that certificate does, it gives the witness immunity from any immunity in this sense, that any of their evidence that tends to incriminate them, or any documents or any corollary evidence or lead-on evidence that arises from their evidence cannot be used in a criminal proceeding against them or a proceeding that produces a civil penalty against them. And it's not something that we often see with medical practitioners and health professionals, but I think it's something that perhaps we don't give enough consideration to. And it may be important that we do consider that we should be asking for certificates for our witnesses in more wide ranging circumstances. What happens is the witness hopefully will end up giving the evidence, but that protection is then afforded to them. I'll leave it there because it's 8 o'clock. Maybe there might be some questions at the end. Thank you.
Thank you very much, Paul. Just one question. Is the certificate that's granted for immunity the same as the certificate under the new Evidence Act?
No.
It's completely separate. Yeah. Thank you. We're just going to have a short break and a cup of